So good afternoon and welcome to the 2012 TARGETjobs National Pupillage Fair. Delighted to welcome you here to the Criminal Law Talk. My name's Kate, I work for TARGETjobs and we do things like the TARGETjobs Law as well as the pupillage handbooks which you should all have. You'll see there's a camera in the room today. That's just because obviously in the past the talks have been so popular and we hate the fact that people sometimes miss out. So this will be on our website from Monday morning as well as on our YouTube channel. So if there's any other talks you've missed or you want to sort of recap anything, also tell your friends that this will obviously be online from Monday. Delighted to welcome here today Stephen Vullo from 2 Bedford Row and Tom Wainwright from Garden Court Chambers. They will be talking sort of about 10-15 minutes about their area of the law and why they went into it, sort of any qualities or skills that they think are necessary for criminal law. Do hold any questions till the end. I will sort of have time for 10 minutes of questions at the end, so just hold any questions till then. So, Stephen, if I can invite you.
Morning, everybody. Another full room every year. We have a full room, which is nice. I'm going to answer the question that all of you want to ask, and that's, is the criminal bar dead? Everyone on the stands walking up and saying, I've been told that the fees have disappeared, nobody can earn any money, and the whole profession is basically dead on its feet. The answer to the question is no, it's not dead at all. The reality of what's happened is that fees have been reduced. The government are reducing fees in everything. It's not just criminal defence work, it's prosecution work and other publicly funded areas of everything that the government has to pay for. So fees have been reduced, but your income hasn't dipped at all because you never earned the extra money that people used to be able to earn at the bar. So from your perspective, and from junior tenants in our chambers and pupils, you'll cut your cloth. If you speak to people who have 25 years calling 2 Bedford Row, they will moan and moan and moan about the fees that they receive, because it's true, maybe 10 or 15 years ago, they would be 30 or 40% higher, and that was 10 or 15 years ago, so when the money was much more valuable than it is now. If I said to you when you were students that, right, your income from whatever job you had or parents, whatever it was, I'm going to reduce it by 40%, you would moan, because you'd be in a position where you'd cut your cloth, you'd rented the flat with a couple of mates that you could afford, you bought the old banger, maybe you did, maybe you didn't, you have 2 nights out when you spend 20 quid in a student bar having drinks, your income's gone down by 30% and you're outraged. And then somebody walks up to you as a student and says, what's life like being a student? Is it worth being a student anymore? And you say, no, it's rubbish. It used to be really good, and now it's rubbish. Apart from if you spoke to somebody that was 1 year on their feet as a student. And they might say to you, yeah, it's great, it's fine. We go to the pub once a week. We go on the bus everywhere because we can't afford a car, and we're in a slightly smaller flat than some of the people 2 years ahead of us. But they're perfectly happy and they're perfectly fine. I know Tom, interesting, we were chatting about this earlier, has got some interesting stuff to tell you about a survey that was done. And what he's going to tell you about the survey that was done accords entirely with my non-data talk to you. I hadn't got any data, this is just my opinion. It seems that the National Stats Office agree with me, which is nice every now and again. Firstly, I am now, I'm 16 years cool, which makes me feel old. My clients include one of the 21st July bombers, the Glasgow bomber, the Saudi prince that killed his slave in a hotel in London. I represented a client on the £53 million Tunbridge robbery, biggest cash robbery in history. A man that blackmailed one of the royal kidnappers, murderers, rapists, and so on, and so on. Why did I go into the criminal bar? So that I would be involved in cases like that, because it's fascinating. And I don't regret one moment of going into the criminal bar at all. And if I could go back now, knowing what I know now and all the doom mongers and people moaning about it, I still choose crime. I did a business law degree because I did intend to make a great deal of money at the law. I think it was my second year at university, I did a crime module, I think, as you have to do, and I loved it from then, and it was crime for me throughout. If you want to be very, very wealthy, go to a shipping set, and when I meet you for dinner with friends, nobody will ask you what you did that day, but they'll ask me. They will. You don't sit down and say, you know, that clause you had in respect to that reinsurance, how did that work out? Like, who cares? But you'll earn a fortune, and obviously, if you do go into shipping, I'll make you pay the bill. But apart from that, as I say, I'm 16 years cool. We were talking about fees and how to present this to you. I make more than headmasters of super schools. I make more than the Prime Minister. I make more than most consultant surgeons that you have. I make more money than them, and yet, if you talk to somebody of my call, usually they'll say, oh, it's woeful, it's difficult, and it's useless. If I told you what fees were in respect of certain cases, given the position that you're in, you'd probably go, wow, and your mortgage will then reflect that fee, and your spending will reflect that fee, and you'll live a life accordingly. The criminal bar, 10 or 15 years ago, was a place where it was full of fat people. I don't mean fat people as in size, I mean lots of people earning six figures that were useless in court. They were lazy, they were arrogant, and they would just go to a decent set of chambers, maybe not even a decent set of chambers, and easily earn six figures, pottering around being gentlemen or gentlewoman barristers. That's what I always used to call them. You can't do that now. If you're in this room thinking it's an easy life to get some money, I don't have to work very hard at it, you're in the wrong room. I don't know if there was a right room here to go in now. You must be dedicated, you must be hardworking. The bar is slimming down, which is good for me. I don't want the competition. If we get rid of the people that were sort of lazy and fat in the way that they did their job, it's good for me. There was more private work around as well, because as legal aid fees reduce. It's not necessarily going to be relevant to you in your first couple of years' practice, but it will be later. Remember, you'll be practicing maybe in 10 years' time. If legal aid goes so low, which it hasn't yet, if it goes to the point where some people, the best people, won't do legal aid cases, it begs the question of, well, if somebody's son, for example, is a medical student and ends up in a fight on the street, and he's going to have a small 3-day Crown Court trial, and his parents look at his whole future going down the drain, and you offer the legal aid lawyer, at the moment you get somebody good on legal aid. But if in 10 years' time you couldn't, what are his parents likely to do? His parents are likely to pay somebody to represent him. If they're going to pay somebody, they may as well pay the best person they can find that they can afford. So I'm not a doom and gloom merchant. I love this profession. It's definitely more difficult. That's absolutely true. It's very difficult now as well, and it's not really the fees, because as I've explained, you don't know you never knew what the fees were anyway, so it doesn't affect you. But what does affect you, and what will affect you, are the increased use of high court advocates, solicitor advocates, in other words. That is tougher, because lots of the small work in Crown Courts that you would hope to do when you're first on your feet is being done by solicitor advocates. This is being filmed at the moment, so I suppose I have to be careful of being libelous. But I wouldn't, in general, want to be represented by a solicitor advocate. And I've seen them in action, and that's why I wouldn't want to be represented on the main by a solicitor advocate. Is that just about acceptable?
I think
just about acceptable. Probably not slanderous. You'll have to compete with those people because they work for a firm who have the work. So you have to be extraordinarily good in a more complex case usually to be chosen to be the person to do it. What they will do, the humdrum easy stuff, the HGA will do. As soon as it gets a little bit difficult, a little bit complicated, it's let's give that one to counsel to go and do. And when you receive it, you must do a very good job. You must show clearly the difference between counsel and HCA, so that when the solicitor's looking at what happens in the case, they know absolutely for sure that they made the right decision to brief it out to counsel. There will always be a referral bar, in my view. I don't see the mixing of the two professions, as some people say. The referral bar might be smaller, but it's definitely going to be there because clients will want, especially sometimes rich and wealthy clients who are used to being able to pay for services that they want at the highest level. They will always want to be able to go to an independent bar and say, I want to choose John Kelsey Fry, for example, Harry Redknapp. He wanted his whole future's on the line. England's future in the Euros apparently on the line. Harry Redknapp has finances, and he chose one of the best barristers of his generation to represent him. He's perfectly entitled to do so. And believe me, I'm sure Mr. Kelsey Fry billed him for it accordingly. But that's fair enough. He's spent his whole career reaching the top of the tree. Last thing I'm going to say, I get asked the question, I'm head of pupillage at 2 Bedford Row, so I read the forms, thank you for all of them, and I do the interviews as well, and I'm always asked, well, what is it? Forms are very difficult. It's 700 applications. I read them with other people in chambers. We pick about 70 to do a first round interview for, where we just see you for like maybe a minute or two. I don't know what the answer is on the forms. It's very difficult. I'll just see something that stands out. Do a mini pupillage in the place that you're applying to. You can't do the paragraph of saying I'm uber committed to 2 Bedford Row, although I've never ever done a mini pupillage at Bedford Row, where we can see the evidence. Okay, so do a mini pupillage. What I would say is once you're through and get interviews, which I'm sure you all were at various sets of chambers, after that there's only one thing that I look for, and that's somebody coming in that can be an advocate, that can stand up confidently and talk. Now, we all talk to everybody through our whole lives, but there is a difference between standing up and being able to talk to a room, or being convincing, for example, to a jury or a magistrate or whatever it may be. We weight people for maybe if they've done the bar course. If they haven't done the bar course, it doesn't matter to us. If you come in and you've done the bar course, I'll expect you to be better than the person that didn't. If you're not, then you won't go through to the next stage. If you're a converting solicitor, for example, that's been on their feet for five years and wants to go to the bar, if you don't come in and you're probably 5 or 6 years better than I would expect a pupil to be originally, then you're not going to get in if you're only 2 years better, because it means you've had all that experience and you haven't done it. The other thing I get asked is whether or not you need to have gone to Oxbridge. As far as I'm concerned, I don't care where you went to university. I went to the City of London Polytechnic, which I think ranks just above Cambridge, but below Oxford. No, it doesn't really, obviously. But I got asked on the stand last year by somebody, what's the mix of your pupils? Are they all Oxbridge? And I genuinely didn't know, and so I had to ask them, and they were on the stand, because it's not something we look at. We look at academic ability, obviously, but when you walk into a room for an interview, just present yourselves as somebody that could be an advocate, and that's it. If you can do that, and do that in a few interviews, you'll get pupillage, and that's it, bottom line, nothing else, because at the end of the day, the job's about standing up and talking. Okay? And be nice as well.
I'm going to start by talking a little bit about the application process and what you've got to come, because I presume most of you will be in the last year of your degree or on your bar course at the moment. You've done extraordinarily well to get where you are. You'll all be very high achievers, but it is probably the toughest challenge that you've got to come in the next few years, because particularly if you're interested in the criminal bar, it is, I think, the most competitive area, the most popular area, and you can see by looking around the room in this talk, it is something that lots and lots of people want to get into, and put bluntly, not everyone can. We don't always get it right either. There's interview processes, there's sifting of forms, there's the pupillage. You have a year-long, 18-month-long interview. We don't always get it right. We've got better, I think, over the years at selecting the right candidates, those who are going to be outstanding at the job. But there is still some crap floating around. And there are still some good people who for the purposes of the tape, there are still some good people who don't get in, and after years of trying give up. And it's horrendous whenever that happens. And I know people that it's happened to. But by and large, it has got better. And in terms of the interview process, barristers are now better trained. The vast majority are equal opportunities trained and have guidance on the interviews and the questions that can be asked and so on and so forth. And the more that people do it, the more astute they are at identifying those prospective pupils who are really going to add something to chambers. But it is still a horrendous, it's a difficult process, it's an absolute nightmare, and I wouldn't go through it again myself for all the tea in China. It took me 46 interviews and 2 years and someone else dropping out before I got a pupillage. And so one of the things that you do need, one of the core things that you do need from this stage onwards is determination. You need a thick skin, and you need perhaps even an element of pig-headedness, because it is going to be hard. Having said that, I imagine there's going to be some people who swan straight in and get 5 offers of pupillage and wander straight into a tenancy and have a fantastic career thereafter. They'll be fine. There's always people like that. But for the vast majority of you, it's going to be hard work. But that determination and that stamina that you'll need to get through the pupillage process will stand you in good stead in your career at the bar, because it is hard work at the criminal bar. Just to give you a little bit of background from my perspective, I'm now at Garden Court. We are one of the leading human rights chambers in the country. I'm a member of the criminal team and I only do defence work. I have particular emphasis on where I can doing protest cases, things with a human rights element to them, but do a wide variety of cases from rapes, stabbings, frauds, drugs, down to the more interesting cases in the magistrates' court where the majority of protest cases take place, and then you occasionally get to visit the High Court, the Court of Appeal, and it's a wide and varied practice. But it is hard work, and as I say, at its best, it's the only job I would ever want to do, and it's one of the most exciting and most interesting jobs that you can do. Take a random week last year that was particularly good. I was in the Court of Appeal. We changed the law in relation to a particular aspect of criminal law. We later on that week getting a not guilty verdict for someone who really deserved it, and then keeping someone out of prison, where if they'd gone, it would have ruined their life and the life of those around them. And there were other constructive solutions that we managed to persuade the judge would be more effective. And you have weeks like that and you're on top of the world. The pay I'm not going to go into in a great deal because it's already been covered. It's right that it is, for those particularly started off in more recent times, it is more than enough that you need to get by, and it pays very well on occasion. The majority of the time it pays extremely well, and particularly in the current climate, we're really not in any position to complain. It's tough for the first couple of years. In pupillage, there isn't always the funding to pay huge amounts compared to commercial chambers. But if you do get through, and again, it's a matter of determination, and it's stressful at times. But once you get through those first couple of years, and if you're successful, you can do very, very well. In terms of, as you said, the survey that was carried out recently, there was a survey of the barristers across the profession in all different areas of practice. And what was noticeable was what we've already thought anecdotally is that those who are 1 to 3 years call are very happy with their lot. Not a lot that they'd change. They'd go through it and do it all again and choose the same career. And then the percentages go down the more years call that people are. And those who are more senior, are less satisfied with their lot. I think, I don't have the exact numbers, but I think there's then an uptake amongst the QCs. They seem to be very content. They generally seem to be all right. But as I say, the bottom end, the junior criminal practitioners are still love their job in the same way that people have been doing for years. Having said all of those good things about it, it's at its worst, it can be an exhausting job. It can be depressing. It's not a job that you go into if you want thanks and praise on a regular basis, because you won't get it from the judge, probably won't get it from your client, you won't get it from your clerks. You may get it from your fellow pupils or tenants, but it's not something that you can count off. You have to have inner reserves to get you through a lot of the time. And when I say it's not at its worst, it's not about the winning and the losing of cases necessarily, because you come accustomed to that. It's about the stuff that goes on in between those fantastic weeks that you have. And there are gaps of months where you're doing really boring stuff. You're doing the interlocutory hearings, you're setting stuff up, you're writing out advices on particularly difficult areas of fraud or something that's not the sexy, glamorous area of law that you really wanted to go into, but that's what you've got to do, and you take the cases that you're given. It's tiring. No one really plans your diary in the sense that you will have judges giving you orders that certain things need to be done by a certain time. If you've got a dozen cases running at the same time, sod's law is usually that you will be told you need to do a response, a defence statement in all 12 within the next week. It's not spread out in that way. There's no sort of overview where you can plan things and pace things. So you will have times when you're extremely busy. You get given trials the night before. You may not have much of a choice in the matter, and if you've got plans that evening, well, it's all shore leave is cancelled and you will have to work through the night to get that trial ready. The only thing that is worse than being extremely busy is not being busy, and that happens as well. Trials plead guilty. You may have expected to be in court for the next 6 weeks doing something or other, and then it pleads, or the prosecution drop the case on the first day, and you're doing nothing, or you're floating around, waiting around for hours in magistrates' court in I think Haverfordwest is one of my personal favourites, Taunton, far-flung areas of the country. Being the first person at King's Cross in the morning or at Paddington is not a fun experience. And there are lots and lots of those times. There are naturally quiet periods when people say, "Oh, there's not a lot of work around at the moment." There are periods. It swings and roundabouts. There are periods where, as I say, it's extremely busy, and you've got more work than you can do. So you need to be able to get through those times. But if you can do that, then, and you're determined that that's the career that you want to do, then it's a fantastic career, and I'd recommend it to anyone. And in terms of just briefly what helps when you're applying to criminal chambers or common law chambers which do crime, whatever it is, what we look for is, to borrow a phrase, that X factor, that thing that stands out. Because we look through 700, 800 application forms, however many it is, we interview as many people as we possibly can. And frankly, it gets a bit tiring. It's often long days doing all of that. And then, having sat on the panels myself, there is someone walks in and wakes you up and they come across and their enthusiasm is there, their presence is there, and those are the ones that get pupillage. Those are the ones that stand out and do really well at the bar, because if they can hold your attention, they can hold the judge's attention, they can hold the magistrate's attention, they can hold the jury's attention, and that's what you need to be able to do. And that's something which, again, you need to have a think about. Do you think that that's something that you can do? It may not come naturally, it's something you may have to work at. And not everyone's a born advocate. But you will need to be able to do that at some point in your career, and that's what needs to come across. So bearing all of that in mind, I just wish you all the best of luck, because it is a very difficult road ahead.
Thank you very much. It sounds a little bit late, so we've probably got about 5-10 minutes of questions. If anyone has a question? No?
Haven't covered everything.
At the back.
So the application process you were saying is pretty difficult, it's pretty strenuous, and it will hurt. Would your advice be just stick with it, keep on applying, keep going to interviews, and just until you get there?
Absolutely, yeah. I mean, it varies from person to person, and there doesn't necessarily seem to be any rhyme or reason to it. Thinking back to when I was going through, and there would be some people who'd be swanning off to an interview every other week, and they'd get hundreds of interviews, and may end up being offered more than one pupillage. And there'd be some people who didn't get offered many interviews, but went to one interview and got a pupillage. Some people who got lots of interviews and no pupillages, like I did. But you've really got to just sort of develop a thick skin. The interview process isn't perfect, as I've said. It doesn't always get the right person, so I certainly shouldn't take it personally if you don't get through in a particular set or something like that. And as I say, well, I think it helps to an extent that it's so competitive, because it causes you to think, do I really want to do this, and how much do I really want to do this? And everyone will have their limit as to how many times they're willing to go through that process and how badly they want it. And I think what it does mean is that those who get it, by and large, are those who want it the most, and the most dedicated and the most enthusiastic. But as I say, everyone has their limits.
You only need one, remember? I was only offered one pupillage, but you only need one. And it's absolutely right what Tom says. It's really not a perfect science when we interview. I know for sure, especially at the paper stage, we're probably rejecting candidates who are brilliant and interviewing people who aren't. But we know that, and I've got no idea what percentage we think we get right, no idea at all. In the interview, if you're getting interviews and you're not, for example, getting second round interviews, or you're not quite getting over the line, then you have to look at what you're doing in the interview. It's the same way as if you go to court and start off doing jury trials, if you get convicted a few times in a row, you want to start looking at, well, what is it? Like, do I need to do something else? In exactly the same way. But don't take it. It's ridiculous, isn't it, really, to say don't take it personally because I have rejected you. But it isn't as personal as you think it is. This is sort of people like me and Tom on the train home. I've got another 100 things to read. I'm flicking through. Oh, she sounds good, and he sounds good, or she doesn't sound good, and I'm doing it on the train on the way home. So if you come for an interview, don't think, well, I've made it. And if you get the I'm not coming for an interview, don't be totally despondent because we're busy and we're not professionals in terms of recruitment. And that's a big thing you have to remember.
Yes.
There was some emphasis put on doing a mini pupillage at the set that you are applying for. Obviously, a lot of us would have done mini pupillages up north where we're from, and it is difficult to do a mini pupillage in London. They're very costly, etc. I'm just wondering, to what extent do you see that in London as a precondition when doing the application forms?
It's not a precondition, but you'd have to probably address it in the form, saying I want, for example, to practice in London. One of the things that we sometimes have a difficulty with, because we're one of the main sets of criminal chambers, we sometimes get people applying from the north, and we're not quite sure if they actually want to practice here, or whether they just want to come down here to do a great pupillage and then go back, which to us then means it's a slight waste of resources and a space for someone who wants to build a practice in chambers afterwards. So that's what they say about that. Deal with it and address it. The other thing you can do as well, and we do it in chambers, is if, for example, it's too costly and expensive for you to come down to do a whole week, then come and do a couple of days. If you've got a friend who lives in London, if you can sleep on their couch for a couple of days. If you explain in the letter that you write that I can't come for the week due to cost, can I come for a couple of days, then that will probably get you over that problem.
And I think actually we take a slightly different view on it, because we have a structure to the mini pupillage system that we offer, whereby the emphasis on who we're looking for is very different. With our mini pupillage system, what we try to do is to give experience to those who don't have experience of the law otherwise, who don't have a lot of mini pupillages under their belts. We're not going to give a mini pupillage to someone who's already done 4 or 5. And we try to give experience to those who aren't as sure about coming to the bar, who may not have considered it before, and who may be from non-typical, in inverted commas, bar background. And so that's who we look for in our mini pupillages. The criteria for pupillage is different. It's open to everyone, and we want the best candidates. And so it's not something that we look for in terms of the pupillage process. It varies from chambers to chambers, because we do bear in mind, as Stephen said, coming down to London for a week is quite expensive. Not everyone has the money to be able to do 3, 4, 5 mini pupillages, and same as other work experience. Not everyone can do the unpaid internships. Not everyone can spend a gap year unfunded building a small village in Outer Hebrides or Africa or wherever. Not everyone has the money, the private funds behind them to do that, and we recognise that. What we look for is, I think we'd expect you do some mini pupillages. It doesn't matter where. I was from Sheffield originally and did mini pupillages there. But you have to show, as that's quite right, that you are committed to the chambers that you're applying to, and that is not only somewhere where you want to do pupillage, but it's also somewhere where you'd like to practice. Really want to practice as a tenant, and that involves obviously for both of us commitment to practicing in London. For us, it involves showing a real commitment to human rights, to social justice, and we have particular ethos that's what we look for. However you manifest that, whether it's through mini pupillages, through voluntary work, doesn't matter, but we look for the evidence of your commitment. And yeah, I mean, it is hard. I think I remember I came to London to do a couple of mini pupillages in some godforsaken youth hostel for 2 weeks, sharing with all sorts of strange people in shared rooms, people coming in the middle of the night, and most of them sort of backpacking around the country, and there's me getting up and putting on my suit and going into looking at some area of construction law at the time, I think.
Misguided.
Which is, yes, largely in order to say, I definitely don't want to do this, I really want to do crime. But you need to be able to have done the mini pupillages so that you know what the lifestyle is like, so you know what the practice is like. It's completely different to what you've studied, and studying criminal law academically really can't prepare you for the actual day-to-day life, and so we need to know that you're prepared for the job itself, not just what you think the job will be like.
Okay, so thank you very much.